So many of us are working from home now, right? And that line between our living room and our office, well, it's pretty much gone. But what happens when the rules of your community haven't quite caught up? Today, we're going to see what happens when your home business goes head-to-head with your homeowners association.
So here's the big question. Can an HOA really reach into your home and tell you how to earn a living? Well, the short answer might surprise you. Yeah, they can definitely try. And today, we're going to see exactly how that plays out.
To figure this out, we're going to look at a real-life court case between the Pointe Tapatio Community Association, that's the HOA, and the Wilkey family. They run a payroll company called Devau Human Resources right out of their home. This one really sets the stage perfectly.
All right, so how did this whole thing even start? The HOA basically went after the Wilkeys, accusing them of breaking the community's rules. Their argument was simple. They weren't just quietly working from home. They were running a full-on business, and that was a no-go.
Okay, and check out this timeline, because this is where it gets interesting. The Wilkeys had been operating from this exact spot since 2009. That's 9 years with no problems. And then, boom, 2018 rolls around, they get a letter demanding they shut down, and before you know it, it's a full-blown legal hearing.
So how did the HOA make its argument? Well, it all came down to one single rule. And all they had to do was prove how the Wilkeys' day-to-day business broke that one rule.
And here it is, the exact wording from the community rulebook, the CC&Rs. Basically, it says your home is for, well, living in. The point of a rule like this is to keep the neighborhood feeling like a neighborhood. But here's the kicker. You can't run a business that creates traffic or parking. That's the super important part.
And this just lays it all out, doesn't it? You've got the rule on one side, and on the other, what was actually happening, which, by the way, the Wilkeys themselves admitted to. They had 2 employees driving in for work on weekdays, sometimes parking on the community streets. So for the HOA, it's an open and shut case, right? This is exactly the kind of thing that rule was meant to stop.
And it wasn't just about the employees' cars either. A quick Google search pretty much backed up the HOA's whole argument. Their business website had the home address listed, with office hours. Google Maps pinpointed the business right there in that residential unit. To anyone looking, this place looked like a regular office, not a private home.
The evidence against the Wilkeys seems pretty solid, right? So what was their defense? Well, they didn't argue about the rule itself. Instead, they based their whole case on, well, a memory, a conversation from nearly 10 years ago.
Their story was pretty straightforward. They claimed that way back in 2009, the property manager gave them verbal permission. They basically said, look, we never would have moved our company here if we hadn't been told it was okay.
Yeah, but there's always a but, right? Turns out when they asked the property manager about this supposed conversation, he couldn't remember it. Actually, it gets worse. An HOA board member testified that the manager actually said he never gave permission. It's the classic he said, she said situation.
And this is the nail in the coffin, really. When the judge asked for any proof, an email, a note, anything, they had to admit they had nothing. Nothing in writing. Their entire defense was based on a conversation that the other guy didn't remember or said never happened.
So how does a judge even decide a case like this with 2 totally different stories? Well, it comes down to what you can prove versus what you just claim. Let's look at how the judge reached a decision.
First off, you got to understand the legal standard here. This isn't a criminal trial, so it's not beyond a reasonable doubt. It's something called preponderance of the evidence. All that really means is whose story is more likely true, even if it's just 51% to 49%. It's just about tipping those scales of justice, even slightly.
And when you look at it that way, the judge's logic was super clear. Number 1, the CC&Rs are a binding contract. Number 2, the rule itself is totally unambiguous. Number 3, the Wilkeys admitted their employees drove and parked there. So, number 4, the conclusion is obvious, they broke the rule. At the end of the day, that he said, she said story just didn't stand a chance against a written contract and facts that everyone agreed on.
So no surprise here, the verdict came down in favor of the HOA. The judge officially found the Wilkeys were in violation of their community's rules.
Okay, so they lost the case. But what does that actually mean? This is the part that should make anyone who lives in an HOA sit up and listen, because it's not just about winning or losing an argument, it's about what happens next.
First up, money. The judge hit him with a $500 fine, a direct hit to the wallet for breaking the rules.
But honestly, the $500 was the least of their worries. The final order was the real blow.
The Wilkeys were given just 35 days to completely stop all business operations from their home, and 60 days to pay the fine. Think about that. After almost 10 years, they had just over a month to shut it all down. Wow.
So, what's the big lesson here for all of us? This whole case is basically a perfect guide on what not to do. You have to read your HOA documents. You need to understand the rules on home businesses, especially about stuff like traffic or noise. And if you take away only one thing, let it be this. A verbal thumbs up means nothing. I'm going to say it again, get it in writing. Always.
It really makes you think, doesn't it? You might have this brilliant idea for a side hustle, an Etsy shop, maybe some consulting work, but it could all get shut down because of one little rule you never even knew existed. The lesson here is so clear. Do your homework first. It can save you a world of headaches and money later on.